digital surfaces. They must be in a place where they will know that they've come in and they're not going to be abused, their data is not going to be mishandled, and that there will be accountability and ethical practices that are going to be employed around that data. Data protection is actually an economic issue. If we deepen and we ring-fence issues around data protection, it simply means that more and more Malawians are going to touch digital surfaces, more and more Malawians are going to go to digital trade, more and more Malawians are going to touch digital transactions. The more Malawians that touch digital transactions, the more we build our digital economy. And by building our digital economy, we all know what the ripple effect is. A digitally enabled Malawi creates more opportunities, gives us more accountability, and most importantly, levels the playing field. It takes away inefficiencies, and therefore it creates a better Malawi for all of us. Therefore, we cannot speak about a better Malawi. We cannot speak about turning around the economy of this country if we do not look at digitalization from a serious perspective. That serious perspective on digitalization begins with data protection. Now, this is why locally we are rolling out the Data Protection Act, and we want to work with you, our stakeholders, both from government, private sector, as well as international partners, that we build this foundation together. Internationally, we have made strides in applying to be accepted into the Budapest Convention. Malawi has now been accepted. I think we are country number 11 in Africa out of 54 that have now reached a stage where we're now being accepted into the Budapest Convention. The Malabo Convention, we have also made progress. We are 2 steps away from being accepted into the Malabo Convention. So you can see that the legal and regulatory frameworks that we as a country need to have to create a secure and more accountable digital space, that is happening. But that's on paper. What we now need to do is to actualize all of these things and make these things happen. We can only do that if us as the Data Protection Authority and you, data processors and members of the general public, are working together and we are all seeing the same end goal. Our end goal is for a better Malawi that is digitally, digitally transformed, that creates a better future for our children and a more secure Malawi for their children. I thank you very much for your attention. May God bless you. May God bless Malawi. Thank you.
Thank you, DG. Truly, we need to ensure that our data is secure if we want to build a digital economy. Now, I'd like to invite the UK Deputy High Commissioner, Ms. Olympia Broby, to give us her remarks.
Good morning. Principal Secretary Baldwin Cheyamwaka, got the pronunciation right? The Board Chairperson of the Malawi Communications Regulations Authority, Mrs. Bridget Chimbwana, the Director General of the Malawi Communications Regulatory Authority, Mr. Daud Solomon, and Mr. Solomon, you're a hard act to follow. I must admit I know less about data than you, but let me try and just say a few words. So good morning. It's a pleasure to be invited to this data protection workshop. Today's workshop is facilitated by the Commonwealth Secretariat, and we have our colleagues from the Commonwealth Secretariat over here, and funded by the UK's Integrated Security Fund. Through this fund, the UK government is committed to £45 million to boost the cyber resilience and security with our partners worldwide. We're proud to support the Commonwealth Secretariat in its goal to strengthen cyber resilience within member states and for free, peaceful online processes. Malawi is one of the UK's closest friends and partners in the Commonwealth, Both our countries share much in common, and we've worked together over many years on the challenges facing the world. We share best practice, and our experience of working together is well demonstrated by this workshop. We're particularly grateful to the Commonwealth Secretariat for delivering the training. Malawi is a firm supporter of the Commonwealth, and this workshop shows how the Commonwealth is still relevant and can deliver for Malawi today. May I just touch on a few of the challenges, and I promise it's a short speech. We know that data is the foundation of our increasingly digitalized lives. In a hyper-connected world, huge quantities of data are being sent and received every second online. It has therefore never been more important that our governments ensure they have rigorous protection in place to ensure their privacy and safety of their citizens online. While it is clear that the online space brings progress and has unlocked incredible opportunities, I'm sure we're all on social media, Facebook, Instagram, Twitter, although it's now called something else, we must admit that the digital revolution is bringing us challenges. And most recently, the rapid development of artificial intelligence adds a new level of complexity. I believe the challenge we face is most visible in the protection of personal data. Sadly, no institution or individual is safe from data theft. Cyber criminals and networks target large states to disrupt our national infrastructure. They target businesses through increasingly persistent ransomware attacks, and they target us all, the citizens, through stealing our personal data. Data is a national security issue and the lifeblood of our future prosperity. We simply must achieve better security outcomes for our citizens. As government officials, the more we embed data in our protection into our policy development, planning and delivery, the better we become in driving responsible data flows that promote trust, interoperability, and high protection standards. So what's the way forward? Historically, the UK has been involved in drafting common acceptable standards for strong data protection regime. This includes drafting the General Data Protection Regulation, GDPR, adopted by European states. We have to applaud Malawi's approach to initiating primary legislation, the 2024 Data Protection Law, to better secure personal and non-personal data, creating a safer security system. The Commonwealth too has mobilised support, including from the UK and Malawi. The 2018 Cyber Declaration agreed within the Commonwealth has seen each member state taking steps to improve their cyber security, build capacity, and share knowledge and expertise. By us being here today, we take a further step to share best practice and to strengthen and build protections for our personal data. I hope this workshop really brings opportunities for discussion, for peer-to-peer exchange, shared expertise, and thank you very much for allowing me to be a part of it. Zokoma Kwambiri. Thank you.
Thank you so much for your remarks and for also sponsoring this workshop, making it possible for us to raise awareness and educate and discuss with the various data controllers and processors. As you may know, the Act is fairly new, so we need this kind of discussion. Now it is my singular honor to invite the guest of honor, the Principal Secretary in the Ministry of Information and Digitization, Mr. Bodwin Chiamwaka, to give us the keynote address.
The UK Deputy High Commissioner, Ms. Olympia Bareko Ruby, have done a very good job on yours, yes, and the board chairperson for the Malawi Communications Regulatory Authority, Mrs. Bridget Chimbwana, and all macro board directors who are present here. The Director General Malawi Communications Regulatory Authority, Mr. Dawood Suleiman, and the head of the Malawi Data Protection Authority, Mr. Daniel Chuoni, representatives, various stakeholders, invited guests, ladies and gentlemen, and maybe it's also appropriate for me to especially welcome delegates from the United Kingdom, especially from the Commonwealth Australia. Thank you for your support, and you're most welcome. And also we have colleagues from Zimbabwe. We usually say Achimwene, you know, Chepali from Zimbabwe. We are at Malawi, Zimbabwe. Beautiful story. And South Africa, but also Kenya. Very, very close. And we have a common goal. You are most welcome. To begin with, the DPA is a new girl in town. And it's a very, very new thing. Just landed in the city and crawling around. So, I know maybe a new boy also. The board chair, Margaret, is a gender specialist, and so she was really looking at me to make sure I balance. Yeah, so a new boy, a new girl in town. But to be formal, it gives me honor and pleasure to stand before you on behalf of the Minister of Information, Honorable Moses Konkuyu, who is not able to be with us this morning. Actually, it's a very busy week for the ministry this week. We have tried to spread ourselves around to make sure that we accomplish what we have to this week. So the Honorable Minister is in Blantyre City, where he's also fulfilling some engagements, but he greets you all, and he would have loved to be here. The Malawi government, through its drive towards Malawi 2063, enacted the Data Protection Act in 2024. The Act comes at a crucial time when Malawi is building the foundations of a truly digital ecosystem. And the emphasis that we are digitalizing, we are pursuing the path for digital transformation, is very clear. The fact that we have a whole ministry that has oversight of this ecosystem, or the development of this ecosystem, and the transformation of digitalization in Malawi. May I also take this opportunity to ensure that really we are on this journey. We have two policies, the National Digital Policy, but also the Digital Economy Strategy. And a couple of others are also coming. So it's a beautiful journey that we've embarked on, and to have friends like the Commonwealth Secretariat, it makes it all more worthwhile. The Agenda 2063 strongly emphasizes digital transformation as a key driver, leveraging digital technologies to bridge the digital divide, foster economic growth, improve access to essential services, and empower Malawian citizens across the country by building robust digital infrastructure and promoting digital skills. So what does this mean? This entails the processing of high levels of data by various players as we move towards digital transformation. And even besides various stakeholders or players processing different data, but each one of us every day, when we pick our phone, a laptop, an iPad, or whatever device we are using, we leave what we call digital footprints. We are leaving personal data on different platforms every day, besides the data that is processed by different organizations. Now, as the government of Malawi and the ministry responsible for information digitalization, we believe that ensuring the protection of data is not only crucial in the digital drive, but a right for all. Digital protection is a right. The Act provides us the means through which we can assure Malawians and build trust in the digital ecosystem. Further, this is a milestone in Malawi's journey towards safeguarding the digital rights and privacy of our citizens. Allow me at this point to commend the Malawi Communications Authority for leading this drive to ensure full compliance with the Digital Data Protection Act and for meanwhile, for taking care of the Data Protection Authority. I hope I'm correct. And in an increasingly interconnected world where digital interconnection are at the heart of our personal, professional, and societal lives, the importance of protecting the data and privacy of our people cannot be overemphasized. Our ministry is committed to ensuring that the fundamental right to privacy is respected and upheld in the face of rapid technologies and advancement. Distinguished ladies and gentlemen, as a nation, we have recognized that the protection of personal data is not merely an issue of security, but like I said, also very important for human rights. The establishment of the Data Protection Authority is a significant step forward in our journey to ensure that data is collected and processed and used in a way that respects the privacy of all Malawians. And the authority will serve as a critical institution in Malawi with the responsibility to protect individuals' privacy rights by monitoring how personal data is collected, stored, and used. The authority will ensure that Malawi's privacy rights are respected and that they are informed and empowered to make decisions about their personal data. This is where issues of personal data consent is very, very important. The will and nilly use of personal data by different stakeholders or those who are concerned. I'm sure the head of authority and the institution, the DPA, is aware that the will and nilly use of personal data has consequences as far as the Act is concerned. But also to promote accountability, the authority will hold organizations and public bodies accountable for their data practices, whether in the private sector or public sector organizations must act. We are talking of financial institutions like banks, insurance companies, and other entities in the private sector. But we are also in the public sector, even medical facilities. And medical data is vital and very private. So hospitals, workplaces, they also have. When you join the government, the civil service, the first form you fill is the GP1. When I started work long ago in government, I still have a copy of my GP1, and where you put all your bio data. This data in the workplaces is also very, very important, and other places where we go. May I take this privilege to use a Chewa term, even with Biriganyo or the village banks, they also keep data. And all that data is very, very, very important. So the handling of data now calls for the accountability, and the PDA will be very responsible and ensure they enforce this. Thirdly, to talk about the role of the PDA is educate and raise awareness. One of the key functions of the authority will be to educate the public and organizations about their rights and responsibilities regarding data protection. We want every citizen, from the young to the elderly, old or young, to understand the value of their personal in the digital space. Number 4, to regulate and enforce compliance. The authority will be empowered to investigate data breaches, issue penalties for non-compliance, and take necessary action to protect citizens from data misuse. I know all over the world there are cases, examples of millions of money lost to lawsuits because of careless or mismanagement of personal data. I can give cases, with AI. I just went on ChatGPT. I said if I'm not going to have a formal, I've just asked ChatGPT to tell me what to talk. And I saw a number of cases, lots of money lost. These are consequences of mismanagement of data. Well, I trust that the government of Malawi, the government of Malawi is committed to ensuring the privacy of its citizens, while also of digital economy. It's a very delicate balance, especially where you have a conflict of rights, privacy, freedom of expression, but they are manageable because laws have to speak to each other, and I think the authority is there to ensure that there are demarcations very well delineated, to say this is private and this is what is for public consumption. By enacting and enforcing data protection measures, we are not only protecting individuals, we are also creating an environment where business can thrive. Malawi is proud to join other nations in protecting the fundamental rights of individuals in the digital age, ensuring that we align ourselves with best practices and global standards for data protection. This data privacy workshop signifies our commitment not only to meet international benchmarks, but also to lead by example in the African region. So, head of PDA, we encourage you to pull up your swords to lead by example. It's a commitment that our government is making here. We can become a model. We have learned from others, but I think there is something, one or two things they can also learn from us. We look to the future with much anticipation, and the digital landscape is constantly evolving so too often, and our efforts will not relent in this pursuit. The Data Protection Authority will need the support of every citizen, everyone, every business, every institution, in order for it to be effective. There is a tendency in Malawi when a new institution is established to look at it and say, let's see what happens. So if we have put it on a pedestal and to wait the day when it will wane and dry. That's not the attitude and the spirit. We all have a duty, a responsibility to support the authority. It's for us, it's for our own good, it's for the protection of our individual personal data. So let's give it support. Let's support it. And the ministry is here to support the authority. Finally, let us all take this opportunity to recognize the importance of data protection and ensure that we all play a part in securing safer, more transparent digital world for present and future generations of Malawi. Let me also take this opportunity to thank the Commonwealth for rendering technical support and expertise to ensure the success of this workshop. I'm sure to demonstrate that we really are grateful, they will treat you to a chambo, our delicious trapia, and very savory, especially in this environment, the served one which is juicy. So please, head of PDA and Daudi, make sure they taste that jambo, because so they know we really have welcomed them. Thank you very much. At this point, I declare the workshop on behalf of the Honorable Minister open and enjoy. Thank you.
Thank you so much, Principal Secretary in the Ministry of Information, and also thank you for your continued commitment towards the drive for the digital agenda. The future is digital and the future is now. So the enactment of the Data Protection Act shows our seriousness towards ensuring that the country moves towards a digital direction, as well as the protection of that digital drive that we are building. We shall have a group photograph after this. We'll have it outside by the auditorium steps. After that, we'll go for tea. Then we shall come back in here where we'll have presentations on the Data Protection Act, which will be taken by the head of the DPA himself, Mr. Dan Chiwone, and his one staff member, Ms. Tamanda. And then we shall have a high-level panel on ensuring compliance or by organization. We shall learn from our neighbors, Kenya, Zimbabwe, as well as Malawi. So I urge you, we have a very high-packed program this morning as well as this afternoon. So let's go for the group photograph, and then let's come back here for tea, and then we shall get right into the presentations. As the high table is making its way to where we've set up, may we please all go and take this group photo. May we please do this so that we can come back for tea? We are all set for the group photo. Those of us still in this room, I'm urging you, nicely nodding you on, may we please go and get this group photograph done. May we not name names? Malawi set team, we see you. May we please? Group photograph. May we not name names? Mr. Njoka, we see you. Group photograph.
two, check two. 1 2 2 2. 1 2. One two, yes, 1 2. Yes, 1 2, mic check 2. 1 2 1 2. One, two, yes, mic check 2.
the head of data protection. As you have heard, the Data Protection Authority is a new baby within MACRA. We are literally breaking new ground and starting from scratch. Issues of data protection, I think Malawi as a country, we have been a little bit late in terms of coming to the party, but I think we'll be able to catch up. And with all your support, I think we should be able to become even a beacon within the region and within Africa. I'm here to present an overview of the Data Protection Act, which I hope will be a foundation of the discussions that we are going to have over the next three days. Being an overview, I was trying to be high level, but I think I have failed in my efforts because I think I have got about 30 slides. But I will try to be as quick as possible and not go into too much detail. So my presentation has got about 6 parts. The introduction, which talks about what is personal data protection and why it matters. Then we'll look at the key definitions. Then a discussion on the principles of personal data protection. We'll have an overview of the rights of data subjects. We'll also talk or briefly discuss the obligations of data controllers and data processors. The majority of the audience here fall into this category. Then we'll conclude and also talk of incoming developments that we intend to undertake as a data protection authority. So, a very high-level definition of what is personal data protection. Basically, is protection of personal information of a person that can be identified. So a very, very high definition of what is personal data protection. The underpinning concepts or cornerstones of personal data protection are privacy. One, we are looking at protecting the privacy of individuals who are called the data subjects. Secondly, we are looking at giving individuals autonomy or control over their personal information, how it's collected, how it is utilized, stored, and shared. Individuals should have a say over all those processes. And why does data protection matter? It matters because it affects all of us. We are all data subjects and would want our personal information not to be misused. Issues of identity theft, fraud, unauthorized disclosure and access of our personal information are things that are covered by the protection of personal information. And again, most importantly for you as data controllers and data processors is an issue of building trust between you and your clients, between you and your customers. They should be able to trust that the information that they have given you will be safe, secure, and protected. So that's why data protection matters. In terms of our legal framework, we have got the Data Protection Act, which was enacted in 2024 and became operational on the 1st of June 2024. So as an authority, as a regulator, we are about, I would say, maybe 9 months old, just a baby, learning to walk, to crawl and walk. And in terms of the objectives of the Act, I can highlight 4 principal objectives of the Act. First of all, to provide for the protection of personal data of natural persons. So the emphasis is natural persons and not legal entities or companies, but natural persons. Then to regulate the processing of personal information and the movement of personal information of natural persons. Thirdly, to provide for the rights of data subjects. And fourthly, to provide for the obligations of data controllers and data processors. And MACRA, that is the Malawi Communications Regulatory Authority, has been designated as the Data Protection Authority. So at the moment, we are wearing several hats as a communications regulator, as well as a regulator of the processing of personal information. And our mandate is to regulate the processing of personal data, to provide for the protection of personal data, to oversee the implementation and enforcement of the Data Protection Act. Now, let's talk about the key definitions that are in the Act. The first one being, what is personal data? And the definition in the Act is quite broad. It means any data relating to an identified natural person. You see that it encompasses and covers a lot of information. Easy examples are basic identifiers such as name, identification number, online handles or online identifiers. Then we've got demographic information like age, gender, race, ethnicity, marital status and tribe, biometric data as we digitalize, fingerprints, facial recognition data, all these form of as part of personal data. Then financial information, bank account details, health and medical information, year status, medical history, professional or employment information, job title, your information as an employee, your employment history, all that form part of personal data, which is the subject of the Data Protection Act. Then the Act has also defined what is processing. Again, the definition is quite broad. It covers any operation or set operations that is performed on personal data. And this includes the collection, recording, organizing, structuring, storing, altering, retrieving, using, restricting its usage, erasing it, and destruction. So any operation or set of operation that is performed on personal data is processing within the Data Protection Act. Then who is a data subject? This is a natural person to whom particular person data relates. Then the Act has also defined who is a data controller, and most of you fall within this category or definition. So a data controller is a person who determines, one, the purpose of processing personal data, the why or the reason or objective of processing personal data. So if you are determining that purpose, if you are determining that purpose, and also you're also determining the means of how personal data is processed, the how, you are a data controller. That's how the Data Protection Act has defined who a data controller is. A data processor is a person who processes personal data on behalf of the data controller. A key feature which I think you notice when you read the Act, a data controller and a data processor can be a natural or a legal person. That's how the Act has defined it. It can be a natural person or a legal person. Then the Act has also defined who is a data controller of significant importance. The reason why we have got this category of data controllers is that the scope of their processing activities can pose a high risk to data subjects, and they require closer monitoring and closer and additional obligations under the Act. So the Act has defined who is a data controller of significant importance. And how it has defined is a data controller of significant importance is a person who is domiciled or ordinary resident in Malawi and processes or intends to process personal data of more than 10,000 data subjects. So if you fall within this category, you are a data controller of significant importance. Or if you process or intend to process personal data of significance to the economy, society, or security of Malawi. So regardless of the number of data subjects whose personal information you have, if you are processing data that is of significance to the economy, society, or security, you are a data controller of significant importance. It has also defined who is a data processor of significant importance, and the similar definition as that of a data controller of significant importance. Now, coming to the principles that govern personal data protection, there are several. And the overarching principles are lawfulness, fairness, and transparency. So the legal requirement is that a data controller and a data processor must process personal data lawfully, fairly, and in a transparent manner. We'll unpack this as we go along. Coming to the issue of lawfulness. When you are processing personal data, first of all, you must have a legal basis for processing personal data. And the Act has given about 6 of such legal bases. The first one being consent. If you have the consent of the data subject to process his personal data, you do have a legal basis. Then we have got the basis of contractual necessity. We unpack this. Compliance with legal obligation, protecting the vital interests of a data subject, performing a task carried out in the public interest, or exercise of official authority, or where the processing is done pursuant to a legitimate interest of the data controller. So when you are processing personal data, you must be able to point out a specific legal basis that you are using to process personal data. If you can't point out that legal basis, then you're on shaky ground. Then the principles of fairness and transparency, there are other principles that feed into these overarching principles, like principles of data minimization, storage limitation, and purpose limitation. We'll discuss these. Now, coming to issue of consent. The processing of personal data will be lawful if the data subject has given you consent to process their personal data. We recognize that in certain cases we have got people that cannot provide legal consent, like minors or those that are mentally incapacitated. In such cases, you get consent from the guardian or parent of the minor, or the person with the mental incapacity. Processing of personal data will also be lawful where you are doing so for purposes of performing a contract or contractual necessity. For instance, if there are online purchases, the online vendor will require details, your name, payment details, and address where to deliver the order. So the processing in that regard is necessary for the performance of the contract. So if you can point to that necessity, you are covered as having a legal basis to process personal data. Then compliance with the legal obligation. I think most of the banks here and telecoms here, they have got know your customer or KYC requirements. If you are processing personal data, because of that legal obligation or legal requirement, then you are also covered. You can also process personal data where this is being done to protect the vital interests of a data subject. For instance, in the case of a medical emergency, and the data subject is unconscious and unable to give consent, the doctor may look at the medical history of the patient and other personal information to provide treatment to that patient. Then we have processing by a public authority under a written law, like Census, National Statistics Office. They will be able to point that we have got legal basis for processing personal data because we're doing so under our governing legislation. Processing personal data is also lawful where you are doing so pursuant to a legitimate interest of the data controller. And the caveat here is that you must ensure that the interests of the data subject are not overridden, or the fundamental rights and freedoms of the data subject are not unduly infringed upon. The example that we can give here is employers having workplace policies where they are monitoring official emails, tracking devices on vehicles. They're doing that for the purpose of pursuing a legitimate interest of the employer. But be cautious to ensure that you do not violate the rights of the data subject. So you must strike a balance, and this can be a trigger basis for processing personal data. Then we have got other principles of processing personal data. We have got a purpose limitation principle. So when you are collecting personal data, you must collect it for a specified and legitimate purpose. You must specify the purpose to the data subject, and it must be legitimate. So as organizations, you must clearly define the purposes for which you are collecting personal data and ensure that any subsequent processing is consistent with that particular purpose. Then I've got the principle of data minimization. Only collect information that is relevant. Do not over-collect information. For instance, if you are a utility organization, do you need to know my marital status for you to give me a utility service? Do you need to know my education level? If that information is not needed or required, do not collect it. Then data accuracy. Ensure that the information that you are collecting is accurate and up to date. If there is inaccuracies, ensure that it is corrected. The storage limitation. A data controller must not store personal information for a period that is longer than necessary to achieve the purpose for which the information was collected. Then there is the obligation of integrity and confidentiality. As data controllers and processors, you are under an obligation to ensure that you put in place appropriate and technical measures to guarantee the security of the personal information that you have collected. So the examples of initiatives that you can undertake include encryption, data backups, having policies in terms of levels of access to personal information, audit trails, and the constant monitoring of the policies that you are implementing. Then the Act has also provided for additional protection of what is called sensitive personal data. And in this category, we've got biometric data, race or ethnic origin data, religious and other beliefs, the conscience of a person, his status, political opinion or affiliation, and such other information which the minister may prescribe. All these fall under sensitive personal information, and there are particular obligations that apply to this. Then you have got an obligation to provide information to the data subject. Such information includes the identity and contact details of the data controller, the legal basis that you are using to collect and process personal information, the purpose for processing the personal information, and where possible, the period that you're going to keep that information. All this information, when you're collecting, must be provided to the data subject. Then you must also inform the data subject if there will be automated decision-making, including profiling. The reason being that the Act has given the data subject a right to object to automatic processing. So it's important that when you are collecting information, you inform the data subject that you'll be subjected to automated decision-making. Then you must also inform them of their rights as provided under the Act. So as an authority, we'll be monitoring to ensure that all these requirements are adhered to by our data controllers and data processors. You must also indicate to him that he has got a right to lodge a complaint with the Data Protection Authority for redress. And you must also inform him if you intend to transfer personal data outside Malawi so that he can give his consent or not. Coming to the rights of data subjects, there are several. One, the right to access their personal information. So they should be able to confirm from you that you are processing their personal data and what kind of information that you have about them. Then they have got a right to what is called data portability. That is, the data subject can require you to give them their personal information and also to require you to transfer that information to another data controller. Then they have got a right to rectification of their personal data, where the information that you have about them is incomplete or inaccurate. They have got a right to request you to correct it or to have a complete record of their personal information. Then there is a right of erasure, where the information is no longer needed for the purpose that it was collected, or where the data subject has withdrawn his consent, or where the processing is unlawful, or where there is a legal obligation to erase the information. The data subject can require you to delete or erase the information that you have about them. Then they have got a right to restrict any further processing of their personal information, particularly where they're contesting the accuracy of the information that you have about them, or where, as a data controller, you no longer need that particular information. Then they can also object to processing where it will cause unwarranted harm or distress. So those are the rights of the data subject. Coming now to the duties of data controllers, a general duty to adhere to the data protection principles that I've outlined and respect the rights of data subjects as outlined in the Act. Then there is a requirement that you have what is called a record of processing activities. So all the processing activities that you are undertaking as data controllers and data processors, you must keep a record, and the Act has given guidance in terms of what this record should cover. I will not go into detail on this one. Then there is a requirement for you to conduct what is called a data protection impact assessment. This is done where there is a very high risk to the rights and freedoms of the data subject. And the Act has provided some guidance where this can be done. Where you are doing automated processing, prior to that, you must do what is called a data protection impact assessment. Where you are processing sensitive personal data at a large scale, you must do what is called a data protection impact assessment. Or where there is systematic monitoring of an area that is accessible to the public. For instance, where you put a CCTV camera. Before you can do that, do what is called a data protection impact assessment so that you evaluate whether the rights and freedoms of a data subject are not at risk. Then you have got the obligation to ensure that the security of the information that you have collected, and you must implement appropriate technical measures to protect the information. Then there is obligation to communicate what is called a data breach. And that obligation is twofold. Where there is a data breach and the information, there is unauthorized access to personal information, perhaps a hacking incident or something of that nature. There is an obligation to inform, one, the authority, that is the Data Protection Authority, and that has to be done within 72 hours of the data controller becoming aware of the breach. Secondly, where the data breach is likely to impact or affect the rights of the data subject, you must also inform them within 72 hours. These are the obligations which the Act has put in terms of notification of data breaches. Then there is a requirement that public institutions must have what is called a data protection officer. Over the next 2 days, we'll discuss a lot the roles of data protection officers. Public authorities and data controllers of significant importance must also have data protection officers. As I said, we'll discuss a lot more over the next 2-3 days on this requirement. So that's I hope, a very high level overview of the Data Protection Act. In conclusion, I think as you notice, personal information touches every facet of our lives: business, employment, and personal lives. And some have even gone to the extent of calling it the law of everything. It touches everything. However, what is key is for us to have a robust framework for personal data protection. And you as data controllers and data processors are a very key stakeholder in this. What we want is to have a partnership between the Data Protection Authority and you as key stakeholders, and having a culture of compliance and safeguarding our citizens' right to privacy. In terms of incoming developments, we are putting in place frameworks for the registration of data controllers. And starting from 1st of April 2025, that's when we are starting this exercise. We hope to cover as much ground as possible within the next 6 months in terms of registration, and putting in place the appropriate documentation and framework for this particular exercise. We're developing data protection regulations and guidelines, and soon we'll again be inviting you for public consultations, but this week we'll be publishing the draft documents for your review and your comments. We intend to finish all these public consultations by end of March, so that 1st of April we hit the ground running. Thank you so much. Yewachomene.
Thank you so much, Mr. Chone. Before you take your seats, may we take comments or questions from the floor?
Thank you very much. I'm James Tanton from the Reserve Bank of Malawi. Yeah, so I have two questions that touch upon the application of the Data Protection Act. So the first question is, I'm assuming that the Data Protection Authority is MACRA. In terms of cloud computing, obviously the data might be stored outside of the Malawi jurisdiction. So what is the position of the authority where the data being processed has conflicting data regulatory frameworks that are conflicting with the current or our Data Protection Act? The second one, I think, is maybe looking into possible destructive technologies. That's, for example, the blockchain technologies. So in their nature, I think blockchain technology is immutable. That is, once data is written to the blockchain, it cannot be destroyed. That's the nature of blockchain. If you destroy the data on the blockchain, it might cause a malfunction to blockchain. Yeah, so there's one, I think there was one provision in the Data Protection Act that you talked about, that is the right to be forgotten or deletion. So what kind of measures are in place to ensure that the blockchain technology does not conflict with the Data Protection Act? Thank you very much.
Thank you very much, Head of DPA. I have two questions. The first one is on the automated decision making. So I think I would like you to expound more on that one, because it leaves room for arguments in terms of defining what is automated decision making. Then also maybe to his point on the issue of data erasure. You have explained in the circumstances, but I also wanted you to expound more, because sometimes people want to have a light to be forgotten, but still more the other regulatory aspects in terms of institutions that have to keep the information. By the way, I work with NBS Bank. Thank you.
We'll take one more for this round, and we'll take three after.
My name is Jacqueline Giles. I'm coming from GIZ. On organizations that should declare themselves as data controllers, you say that the other provisions, organizations that are public or they have a significance to the economy. I'd like to know what measure, how are we measuring the significance, in what range is it? Yeah.
Mr. Chone, you can take those ones.
Thank you so much for those very good questions, and I think it's a good discussion point. I think these are issues that we have to discuss as we have this workshop. Now coming to the issue of cloud computing and the transferring information outside Malawi. The Act has provided guidance in terms of how this should be done. And the guidance and the standard which the Act has put in place is that of adequacy. Wherever you are transferring personal information abroad, the Act allows that to be done if that destination country or destination organization or institution has in place what is called adequate data protection measures. So the standard is adequacy. So as an authority, we have to assess the destination. Is it providing adequate protection or safeguard to the personal information that is there? If not, then the transfer of that personal information outside will be in contravention of the Act unless certain exceptions are met. But as a general principle, is that of adequacy. So if for cloud computing and for servers that are located abroad, we must ensure that where the servers are located, there is adequate protection of that personal information. Otherwise, that transfer of information abroad will be in contravention of the Act. Then the issue of, I think, blockchain and the right to be forgotten. I think the issue there is which one must align to what? Should the Act align to blockchain, or should blockchain and technologies align to the law? It can be a tricky question or tricky answer, but the position as it is at the moment, technologies must align to the standard that has been set by the Act. So, under the right to be forgotten, if the requirements under the Act have been satisfied, then the data controller will have to align and erase that information under the right to be forgotten or erased. Remember, I said there are certain conditions that have to be satisfied. For instance, where that information is no longer needed or necessary. So technology has to align, in this case, with the standard that has been set by the law. Then there was a question on automated decision making. How do we define it? So automated decision making is decision making where there is no human involvement in the decision making process. You have got a system, a machine, and you set parameters within that system, and that system makes decision on data subjects. There's no human face, no human element involved in the decision making. So that's the automated aspect, and which the Act, recognizing that it can pose a high risk to data subject, has given the data subject a right to object to such automated decision-making process, because it can lead to unwarranted discrimination, unwarranted profiling, and such other risks. I think data erasure. I think it was also a question that I think arose. I have just forgotten in what context. But then what I wanted to say was that apart from the standards which the Act has provided and the rights which the Act has given to data subjects, there are certain derogations or limitations to those rights. So where information is being kept in the public interest or for national security and the like, that derogation will override the right of the data subject to erasure. But the derogation has to meet the prescriptions of the Act as well as the prescriptions of the Malawi Constitution. So there are derogations in certain circumstances. Then there was a question of what is information that is significant to the economy. I think I can give examples. Financial information, health information. I think those are just maybe one or two examples of information that can be of significance to the economy. As we are testing the limits of the legislation, we'll be able to maybe categorize, but the risk with categorization, you risk omitting out certain very important categories of information under this definition. Thank you so much. I don't know if there are any follow-ups or additional questions.
We'll take 3 more from the floor.
Hello, regulator. Our new regulator. Nice to see you again, Councillor Dan.
Thank you.
I think my main query is we fully understand. You said that the DPA is a new baby on the block. I think that's the term we've adopted for today. I assume you won't be happy if we use it going forward, but for now, we'll adopt it. In relation to compliance, how are we going to deal with the time frames of compliance? Because you've referred to what significant is. Just as an example, now the Act gave until December for significant data controllers and processors to start complying. I think what we've seen is that this is quite technical and it's going to take time for us to even start doing the impact assessment. So as the DPA who was created after the date of compliance, how are you going to deal with that gap in the law to let us know officially what the date of compliance will be going forward? Thank you.
Yes, thank you for that very important question. Indeed, the period of 6 months had been set, and we admit that it hasn't been met. However, I think from the informal discussion that we have had with a lot of data controllers in the room, we have to be encouraged. We have to be encouraged in the sense that most of you are willing to comply. You have approached us so many times that we want to comply. So, as we start, I think on the 1st of April, I think we'll make a formal communication in terms of the period for compliance so that everyone is guided. I think the key is starting on the 1st of April, but the exact period I think we'll have to come back to you, then set that this is the deadline for compliance. So as we speak, you're in the grace period, which we hope will end as soon as possible. Thank you.
Thank you, Mr. Chone. A hand for Mr. Chiwoni. You can take your seats. May I request Amanda Kamundi? She is the other staff member of the DPA to give us her presentation.
Good morning, everyone. My name is Amanda Kamundi, and I'm the Data Protection Enforcement Officer. I'll be making a presentation on a compliance checklist for data controllers and processors. So following the presentation by the head of data protection on the overview of the Data Protection Act, I'll be stating what is expected of you as a data controller or a data processor. So to begin with, I'll take you through the geographic scope to say, as a data controller or a data processor or someone who is handling personal data, are you falling within the scope that is provided within the Act? So we're talking about, are you domiciled or ordinarily resident or operating in Malawi? So if the answer is yes, then you have to, you have to verify whether you are operating or domiciled within Malawi, and if the processing of personal data is that of the data subjects of Malawi. So if you respond to both questions in affirmative, then it means that you have to comply with the Act. So it doesn't matter whether you are a data controller or processor of significant importance, as long as you're falling within this geographic scope, then you have to comply with the Act, except for the part of registration, which is actually my next slide. So in terms of registration, we're saying that only data controllers or processors of significant importance are the ones who are required to register. So what do we mean by a data controller or a processor of significant importance? So this was already defined by the head of data protection to say these are the ones that are processing personal data of more than 10,000 data subjects, or that which is of significant importance to Malawi's economy, social and security, in essence, to the public interest. So, what are you going to be required in terms of registration? So there'll be a prescribed form which is going to be provided in the regulations and guidelines that we're going to publish. So you have to submit that application, and this is also going to be on the Data Protection Authority website, which is www.dba.mw. So you can actually, you'll be registering through a portal there as well. And this will be accompanied by prescribed fees. So there'll be different tiers where you have to see now to which tier you fall within, and then you'll be able to determine the fees that you'll be required to pay. The other one is that you have to notify the authority. So in the prescribed form, there'll be entries that you have to make, notifying the authority of the personal information that you're processing, to say what type of personal information are you processing, what safeguards are you putting in place, and also the number of data subjects that you're processing their information. So when you go through the Act, you see that there are obligations of the data controller and the processor. So one of them is that you have to comply with the data protection principles. So remember when the head of data protection was making his presentation on data protection principles, you have issues, for example, of data minimization, to say you should only collect and process personal information that you actually need. So you can actually combine in terms of the principle of purpose limitation and data minimization to say, what is the purpose for you collecting that personal information? To say, do not just collect personal information because you're going to make that personal information vulnerable to data breaches. So you have to be well conversant with the data protection principles so that you can implement them in your handling of personal information on a day-to-day basis. The other one is that as a data controller and the data processor, you have to ensure that you have a legal basis for processing personal information. So Mr. Chiwoni did state some of the things that are regarded as legal basis for processing data, for legally processing information. So one of them would say if you're a party to a contract and one of the terms required you to for the processing of your personal information, then that would fall under a legal basis. Or to say that you have to ensure that you obtained the consent of the data subject. And remember, when you're obtaining the consent of the data subject, it should be freely given and unambiguous. So unless you have a legal basis for processing personal information, then you can process the personal information. Of course, there are exceptions to say if, let's say, for example, there is the judicial proceedings against the data subject, then in that case, for example, you wouldn't be required to obtain consent. So you have to be well conversant with what is regarded as legally processing of personal information and what are the exceptions. The other one is that you should review your data processing activities. So when you decide to collect or process personal information, you should ensure that you identify the data processing activities that are going to be involved. So let's say, for example, you're collecting personal information. What type of personal information are you dealing with? Is it just normal personal information, or you're dealing with sensitive personal information? In that way, you'll be able to determine the safeguards that you have to put in place. How should you handle sensitive personal information or just normal personal information? So you can come up with a checklist, and you can also do what is known as a data protection impact assessment. I'll talk about that as I proceed with my presentation. So I'll now take you through the other obligation of a data controller or a data processor. So this is to implement appropriate security controls to ensure that personal information that you're handling is safeguarded. So these are grouped into technical controls, you have administrative controls, and physical controls. So for example, on technical controls, you can use, let's say, for example, encryption or pseudonymization. For administrative controls, you can have standard operating procedures in your organizations to say which are, according to the personal information that we're handling, which safeguards would be appropriate for the information that we're processing. And physical controls. So you find that most of us haven't really gone digital, and we end up collecting personal information in physical forms as well. So for example, I'll give, when you were doing your registration, you had to put down your names. So in that case, we'd have to put physical controls as well to say, how are we going to safeguard those registration forms that you actually put? And also, this could also include putting CCTVs around the campus of your organizations. So in terms of putting a CCTV, you should know that you're also processing personal information in that case. So you should remember to put a signpost that this place is being monitored by a CCTV. Okay, now I'll take you through the other obligation, which is on the data protection impact assessment. This is more like you're doing an audit on yourself, but it could be a bit different to say you are required to do this before you do any project that requires you to handle personal information. So this is going to help you determine the type of personal data that you're dealing with and what safeguards you have to put in place. And this is also going to help in terms of when you're doing your registration with the Data Protection Authority, or when the authority comes to audit you, because we'll need all these records to see if you're handling personal data according or in compliance with the Data Protection Act. So as I've said, to say the authority will need a record of your processing activities, and this is what we call a ROPA. So you have to ensure that you record everything at the point of collection, to say whether the data is in transit or the data is at rest. You have to ensure that you're recording all this so that we can keep track of how you're handling the personal information. The other obligation is that you have to notify the authority in terms of a data breach, whether there is a data breach or there is potential for a data breach. So this has to be done within 72 hours according to the Act. And the Act states that you have to notify the authority once you receive a data breach within the 72 hours. And in some cases where there's a data breach involving data subjects of, to say the personal information is of high risk, then you're also supposed to inform the data subjects, and you have to inform them within 72 hours. If you are a data processor, so remember, a data processor is processing personal information on behalf of the data controller. So if you are a data processor and the breach happens when you're doing the processing, you have to inform the data controller who contracted you to process that personal information within 72 hours, and that data controller has to report to the authority, the data protection authority of the breach. The other one is on a designation of a data protection officer. So a data protection officer is the person that will be responsible for informing and advising the data controller or the data processor in terms of being compliant with the Data Protection Act. And this DPO, the Data Protection Officer, will be the point of contact between the authority, the DPA, and the data controller and the processor. To say, for example, if there's a breach, it's going to be the DPO that is going to be reporting to the authority. And also, when we're auditing the data controller and the processor, it's going to be the DPO showing them around on the ROPA and everything else. But otherwise, the role of the data protection officer is to inform and advise the data controller and the processor. So who is a data protection officer in terms of what is required of you to be a data protection officer? So it has to be someone who is well conversant with data protection laws and should undergo training as well. So the DPA will also be conducting trainings. These would be certified trainings whereby every data controller and processor will be required to have a data protection officer trained by the DPA. So it is very crucial for public institutions and data controllers and processors of significant importance to have data protection officers. So I think most of the questions come in on issues of cross-border transfers. So on issues of cross-border transfers, you have to report to MACRA which countries the data that you're handling is going to be exposed to, so that MACRA can now, MACRA, the DPA, can now determine whether the laws of that country will be adequate to ensure that the data or information that is being cross-border transferred will be safeguarded. And in cases where the laws are not adequate, then you have to form agreements, and MACRA will also assess those agreements to ensure that the personal information is safeguarded. So remember, the whole purpose is that for so long, data subjects have been giving out their personal information to us as data controllers and processors, but they haven't had the autonomy to have control over their personal information. So essentially, it's to ensure that they have control and know what is happening with their personal information to ensure that it's safeguarded. So that's a summary of the obligations. So as staff, or DPOs, or some just handle personal information and are not necessarily DPOs. These are your responsibilities to say that you have to ensure that you understand the policies and procedures that will be put in place, and you have to be well conversant with the Data Protection Act if you receive any report on a breach or potential breach, you have to report to the authority. So it shouldn't be an issue to say, oh, it was just potential breach, so we thought we shouldn't report to the authority, or we thought it was not that serious. You still have to report to the authority. So you also have to maintain confidentiality and be well conversant with the data protection principles so that you can implement them in your handling of personal information. You should be aware of data security measures that are in place in the organization. You should respect the rights of the data subject. To say, let's say, for example, a data subject comes and they would like to access their personal information, and you deny them that right. That is wrong, because they have the right to access their personal information, to know what personal information you have on them and how you're safeguarding the same. So you also have to engage in continuous learnings. So after this workshop, it doesn't mean you don't have to engage the DPA. You should still contact us, because we've been doing trainings. I think we've done with Arcades, we've done with Nico. Yeah, we've done with several data controllers and processors. So you should continue to engage the DPA so that you can continue learning and being well conversant with the data protection laws. And also remember to document your record of processing activities. So that's just a self-checklist as a person who is handling personal information. I'm going to share the slides so that you can follow it through. So what is the next step after learning all this? After knowing having an overview of the Data Protection Act and knowing what is required of you as a data controller and a processor, you need to conduct what is known as a gap analysis. So when conducting a gap analysis, you look at where you were before you came to this workshop and what you've learned, and then you're going to come up with a desired part that you actually like to be compliant with the Data Protection Act. So you also have to document these things to say, for example, we didn't have security measures in place to safeguard personal information, or we were not determining the type of personal information that we're handling. You can conduct the gap analysis, and it will help you know how you haven't been compliant and how you can actually be compliant. So the duties of the authority, the Data Protection Authority, to promote public awareness on data protection laws. So as I've mentioned, we've been doing trainings, and to encourage any technological advancements in terms of safeguarding personal information. And we also do this, we work together with the Money Fund to say if you have any technical advancements that you'd actually come up with, then we can help you advance the same. We also advise on government policy, receiving data protection complaints, investigating the same, and enforcing them. And also to ensure that you comply with the Data Protection Act, you register and pay fees, which will start in April, as the head of data protection mentioned. So that's the end of my presentation. Thank you.
Thank you. Before you take your seat, may we have 3 pertinent.
Thank you so much for such a comprehensive presentation, Council. My question really is about the law. To say it's one thing to have the law in place, but it's totally different thing when it comes to enforcing the same. And I think on duties of the authority, you informed the House that the authority will be there also to enforce on breaches. Now, I'm interested to know, how does the authority intend to enforce the breaches? especially when it comes to data breaches? How does it intend to enforce that? I know one of the things that you also said was to do with levies. I know collecting levies maybe from various institutions may be easy, unlike enforcing the law. So just share with us, how does you intend, or your authority intend to do that? Thank you.
Thank you very much for the presentation, Council. My questions relate to the application of the Act. The first question specifically relates to concepts to do with domicile, residence, and operating in Malawi. Specifically on residence, I just wanted to know the connotations as to what it means, because I know some statutes specifically define issues to do with residence based on the principles or the policy behind the statute. For instance, a residence for taxing purposes can be different with the definition of residence for adoption in other cases. So I just wanted to understand for this specific act, how are we going to define those legal concepts? The second question relates to the exceptions. I think there's an exception under Section 3, subsection 2B, that the Act does not apply to mere transmission of personal data through Malawi. So I just wanted to understand what mere transmission of personal data entails, and perhaps whether the same exception applies to cross-border data transfers. Thank you.
Yeah, thank you. Yeah, I just have one question. I think it's particularly on the data protection officer. So I'm asking in the context of a relatively large organization where there's a maybe separate legal department and an ICT department and other departments. So from your recommendation, where exactly is this data protection officer supposed to work? Which kind of department or which area can they work under? Thank you.
I'll start with the first question on enforcement. So when you look at the Act, I think it's the last sections, it talks about there will be penalties that will be put in place. So in some cases, we'll be penalizing those who are not in compliance, or if there's a data breach and it occurred because there was negligence on the part of the data controller or the processor, then there are fees that are going to be, there are fees according to the Act that are placed to say they will be fined those amounts. In some cases, like for example now, because we're in the first stages, in the initial stages of setting up, and as the data controllers and the processors, you're still finding your way out in compliance, to ensure that you're complying. In this case, what we're doing in terms of enforcement is just to ensure that we bring the parties together, and then we can resolve the issue amicably to say what went wrong and how can we ensure that this is settled. So that's in terms of enforcement. And the detailed guidance on enforcement will be in the guidelines and the regulations as well. On the data protection officer, so it doesn't matter where they're in they're a technical person or they're from the legal profession, as long as, remember I said they're well conversant with the data protection law, then they can be a data protection officer. So remember, their duty is to inform and advise the data controller and the processor. So it can either be from a technical background or a legal background. To respond on the question, I think it was on the geographical scope. So if the data controller or processor or the person that is handling the personal information is domiciled, ordinarily resident, or operating in Malawi, as long as they are handling personal information of the data subjects, then they will be regarded as the data controllers and processors, and they have to comply with the Act. Yes.
Thank you, Tamanda. A hand for Tamanda. We'll go right into our panel. I will invite Thokozani Chimbe, MACRA's Director of Legal Services. She'll be our facilitator for this panel on compliance with the organizations, best practices, and lessons learned. Thokozani Chimbe.
Good morning, everyone. Good morning, everyone. Seems like we are all busy, but I would like to ask for a favor. Let us try to at least pay some attention and closely listen to the deliberations that are going to happen. And especially, let's try to, as much as possible, to engage, ask those important questions. But without much ado, I would like to thank you for joining us for this first ever workshop by the Data Protection Authority. I am Thokozani Chimbe. I'm the Director for Legal Services at Malawi Protection Authority. My job this morning is basically to this important session, as mentioned by Lemi. The title is Ensuring Organization Compliance, Best Practices and Lessons Learned. And we are talking about best practices and lessons learned, and we have the pleasure of having some pioneers in data protection within the region, trailblazers who will be part of our panelists. And without much ado, I would like to call upon our first panelist. Her name is Immaculata. Sorry about that. Her name is Immaculata Kasaiti. She is from Kenya, and she is the head of the Data Protection Commission in Kenya, the first ever. She is a legal advocate with over 14 years experience. She is also the first vice president of the board of the network of African data authorities. And I would like to give her a big hand of applause as she's joining us. The second trailblazer is Titi Mariwa. Titi Mariwa is also a legal advocate with over 20 years experience. She is also the head of the Data Protection Authority in Zimbabwe, which is also under the regulator POTRAS. Titi was also in charge of setting up the first ever Data Protection Authority in Zimbabwe. She has also been in charge of making sure that they have the right legal and regulatory framework and the right setup. Let us give a big hand of applause to Titi. Our last panelist is none other than the head of the Data Protection Authority for Malawi, the first ever. His name is Dan Chuoni. You already know him from his first presentation. Dan is also a legal advocate with over 15 years legal experience. And Dan has worked as within the authority, and before becoming the head of the Data Protection Authority, he was the Deputy Director for Legal Services at MACRA. Dan has has his master's in ICT law and has a lot of experience on data protection. Let us give Dan a big hand of applause. Without a doubt, we are living in a world that is governed by technology and data. And compliance with data protection is not just a legal requirement. It is an ethical obligation that impacts on any institution's integrity and trust, that most organizations that would like to operate in this digital age needs to comply with. I have with me here panelists from Zimbabwe and Kenya who will be able to share experiences on how best we can ensure compliance as we, Malawi, implement our data protection laws. And without much ado, I would like to let my panelists in 3 minutes introduce themselves, give us a brief background about their experience, and also maybe give us the lessons learned in their countries on how they dealt with compliance. I'll give this first question to Immaculata. Over to you. Please introduce yourself.
Thank you, Tokozani. I want to adopt the already established protocols in recognizing the PS in his absence, the Deputy High Commissioner for Britain and the Commonwealth, and of course the board members and the DG who are here today, and my colleagues in data protection. I don't know whether we speak to highlights of where we are coming from or we go straight to the questions. What do you suggest?
I would like you to just briefly introduce yourself. Okay. And if possible, just talk about one lesson that you would like to share with the audience today on how you think it was a best practice in data compliance, data protection compliance, I should say.
Thank you. My name is Immaculate Kasait. I'm the Data Commissioner for Kenya. And thank you for your warm hospitality in Malawi. It's my first time here in this part of the continent. I think we tend to fly over to South Africa. So I'm very, you know the hospitality when you go to the menu of food, and there is food to pick from. So you know you're home. And when you listen in and everyone is speaking a bit of Swahili, so you know it's okay. You're fine. Even if you get lost, you'll be okay. Anyway, just coming straight, I got appointed to the Office of Data Commissioner slightly over 4 years ago. That is November 2020. And it's been 4 years, a roller coaster of emotions and experiences. For me, we could talk a lot, but the biggest lesson learned I would like to take to the audience, I think it's political goodwill. Without political goodwill, it's next to impossible to implement data protection. You will rely a lot on your stakeholders, whether it's in government, whether it's in parliament, whether it's in civil society. That's a fundamental in terms of making a new institution succeed. I'll stop there for now.
Thank you so much, Immaculata. Titi, can we hear it from Zimbabwe?
Good morning, and thank you so much, Madam Moderator. I would also like to ride on the already established protocols, and definitely would certainly also acknowledge you, DG. Thank you for the opportunity to extend it to Zimbabwe, to come to Malawi, which is our second home, considering our history of the Federation. So I'm basically coming home to share with my fellow countrymen in Malawi. So thank you for this opportunity, and I would also like to extend warm greetings from our Director General, Dr. Machengete. I will not forget to thank also Commonwealth for sponsoring or supporting this initiative, which I think will go a long way in terms of implementing data protection in Malawi. My name is Tsitsi Mariwo, and I am the Pioneering Director of Data Protection in Zimbabwe. And the moment you say pioneering, you are saying a lot of things to the audience. You are saying, as a pioneer, it is never easy to start data protection. You are always called, I have heard already the words in the room, the new kid on the block. It's as if you're not sure of what you are doing, you are taking baby steps, you are yet to realize your full potential. So everyone is questioning what you are trying to do in terms of realizing the right to privacy, which is already in the Constitution of Malawi. So in Zimbabwe, it was also the same thing, where everyone in the industry, because now with data protection, you are regulating everyone, all sectors of the economy. And everyone was skeptical about whether this thing will fly or not. There are always those regulatory overlapping interests. Some regulators think you want to regulate them, despite appreciating the fact that issues to do with collection of personal information affect everyone, even the judiciary, the police, the defense, everyone, even other regulators. So for us, the biggest lesson in Zimbabwe is that you have to constantly take along the audience with you. You have to constantly take along the stakeholders with you. So collaboration has been something that's been pivotal, and that we have learned to bring everyone on the table, to appreciate that as MACRA, as the Data Protection Authority of Malawi are implementing this mandate, it is a constitutional mandate, because the Data Protection Act in Malawi is giving effect to that right to privacy, which is in Section 21 of the Malawian Constitution. So data protection is not going anywhere, but what we have to do is to revise the way we were doing things so that we comply with data protection laws. I think I'll end there for now. Yeah, thank you.
Can we hear it from Mr. Chuoni from Malawi? Can we hear about the Malawi perspective?
Thank you so much, Suzanne. Let me echo my colleagues here by thanking the Commonwealth for supporting us, the DG for allowing us to be here, and all the stakeholders that are present. As already introduced, I'm Daniel Chuoni, the head of data protection at the Data Protection Authority. Now 3 weeks old as a data protection regulator. In my past life, I was a communications regulator for the past maybe 12 years. Going forward, I intend to learn a lot from my colleagues, Sisi and Immaculata. Sisi, we have known each other for a very long time. I think I'm following her footsteps. She was also a communications regulator before moving to data protection. So I think we'll be able to interact and learn a lot from each other. Drawing from my experiences as the communications regulator, and I think something that Sisi has touched on is collaboration and stakeholder engagement. I think we achieve a lot as a regulator if we collaborate and engage our stakeholders. They are very key in all this. We cannot achieve privacy or data protection without their involvement. So we'll carry them along, and we hope to get their support as we start on this particular journey. Thank you so much.
Thank you so much, Dan. We've heard from our panelists that one of the first lesson or experience they would like to share from their side as being very critical for data protection include having the political goodwill from all relevant stakeholders, from government, parliament, to civil society, as well as the data controllers. We've also heard that collaboration and stakeholder engagement can be key in ensuring data protection, compliance with data protection. I would like to remind the audience this morning that as we are going through this panel discussion, we should remember that the two key issues for discussion are practical strategies for aligning with data protection laws, the pivotal role of a data protection officer in driving compliance. So that takes me straight to the next question that I would like to pass on to Immaculata. I know Kenya has made great strides in having a proper data protection framework. Can you share highlights with our audience this morning on some of the practical strategies that organizations in Kenya have successfully implemented to ensure compliance with the data protection laws?
Thank you. I will address that question in two fronts. One from a regulator's perspective, the second one from industry perspective. And just speak from a regulator, I think resource allocation is a very important practical expectation, because without resources, you cannot do anything. From Kenya, we managed to move from a budget of 5 million Kenya shillings, which is like 38,000 US dollars, to what we are at 800 million, which is almost $6 million in 3 years. I'd say 3 years. But why do I say resource allocation is critical? It's because I want to believe we have adopted similar regulatory adoption of budgets. You go to parliament, it goes to National Assembly. We always have what we call limited envelope and then negotiation. So you really must look for a way of making sure you convince parliament and also stakeholders in your sector why you need additional resources. You're a new kid on the block. So it goes back to the fundamental of explaining to people why data protection is critical for us. Two is the issue about, a practical example is developing of regulations, which I'm happy, Daniel has talked about it. It's not possible to implement data protection without the regulatory framework. And also of importance for us, because one of the biggest, and you'll hear from the room, people are anxious about what does this mean. So awareness creation becomes an important aspect. For us, from an awareness creation and what made it important, we realized that from the word go, we did not have the necessary capacity. So we decided to partner with the Kenya School of Government. We also noticed at that point the uptake was low, so we also went ahead and accredited data protection providers. Even then, there was still less uptake because people don't want to pay. Businesses are straining. I think post-COVID, many businesses have issues. So what we've done this financial year is to actually set aside money for those we are partnering with to put money to be able to create awareness. But why is awareness important? I had questions in the room around, people are keen to hear what the regulator will be doing on compliance. awareness is important so that you work with the industry hand by hand so that they understand what are the do's and what are the don'ts. So awareness become a practical example through coming up with the curriculum and also roundtables with stakeholders. It's been talked about here. We had so many roundtables with stakeholders, and I'm very impressed. 3 months welcome into this side of the world. There is a lot of warmth. I know you and Titsi have been in regulators for telecommunication. You can keep that aside. We have Network for African Data Protection Authority. We have many others. Please come to our side. And I want to assure you as Malawi, just like Zimbabwe was able to join the network, you're free to apply. So another practical example is getting the networks. Because what that does, it gives you warmth. You are able to take a call, ask. We called Ireland, ISO, we called the UK, just to find out what they were doing on enforcement. And it's not unusual to be between the office, which brings me to the other practical example. Getting the proper talent. My MBA class lecturer used to say, getting the right people into the bus and to the right seat. If you don't get the necessary human resource, you're going to have a challenge. And by the way, we are all not experts. We all went to law school, the 3 of us at least. And one of the things you're told about law school, a lawyer is a jack of all trades and a master of none. So that you have the basics in law school. So you really can quickly evolve and learn this. So when I say the necessary human resource, it means the right attitude. Because we are all learning issues around data protection. So if you get people with the wrong attitude, and I don't want to sound ageist, but it helps to younger people, millennials, Gen Z, never mind, they might give you grief. Nonetheless, please do not throw stones my way. I'm just saying the reality. Managing Gen Z is quite a full-time job, but nonetheless, that's the people you need because they are natives in IT. Imagine, and this was deliberate, getting, I tell people in my office I'm the oldest, getting baby boomers to come and discuss data protection. You're going to have challenges. I'm not saying they will not learn. I'm just saying just get people with the right attitude, much younger if possible, in terms of human resource. The other one is, I've talked about, it's strategy. I'm happy the Commonwealth has facilitated this workshop. Speak to donors, because at times it's difficult to get resources, to give you a 100 days plan. 100 days plan sets the ball rolling, so then it keeps you accountable in terms of what you want to do. So that is from a regulator's perspective. Let's come to the industry. From an industry perspective, I think the same thing, resource allocation, because many times the board tend to see data protection as an additional layer to compliance. So it's important to convince the board that why data protection is important, especially around issues of trust, and that this is the only regulatory framework globally that gives us anonymity in an era of capitalist surveillance. I repeat, data protection is the only regulatory framework globally that gives you back anonymity in an era of capitalism surveillance. We all embrace technology, we are all in tech sector, but we forget one thing. It takes away our anonymity. It treats us like goods and commodities. We are not asked where we want to be, what we want to do. Our anonymity, our individualism is taken away and traded. The only regulator that helps bring sanity to that space is this. There must be guardrails. There must be guardrails. Otherwise, we all lose it all. We all lose it all when it comes to our children. So please convince your board why. And that's it. Because if you build trust with your customers, then they give you more business. They know you're not misusing their data. So under that, please, it's important to appoint a data protection officer. It's so important because then they're able to map where data is being collected, how it is processed. And then they're able to then infuse principles on data protection. 3, develop a data protection policy in your office. And when you do that, you then also come up with SOPs, standard operating procedures. Train your staff. It's a new kid on the block, but we are not taking prisoners. Get your act together. I'll stop there for now. Thank you.
Thank you so much, Immaculata. We've heard it from the pioneer, one of the trailblazers in Kenya, that when it comes to practical guides on compliance for industry, clearly is resource allocation. As we are living here, please, let's convince our organization that we really need to allocate resources towards data protection, convince those boards. Appointment of the data protection officers. I think Tamanda also emphasized on this, Dan as well. It is critical to have a data protection officer. For significant data controllers, it is mandatory under the Act. Developing of data protection policies is key. Again, having standard operating procedures is something that we need to also take heed of. For the regulators, resource allocation has also been cited as key. Development of regulation to actually lay the right legal framework to explain some of the things in details. Awareness creation, as we are doing right now, is also key to help us walk hand in hand. Getting the right networks. I hope, Dan, you've heard this. At least we know there is that network of African data authorities. I think that should be one of the targets for our data protection authority. And again, we've also heard that it is also always key to get the right human resource. I think this applies to both. There's this saying when it comes to cyber crimes that all the time when hiring HR, you always have to, there is always this thing they say, hire attitude over competences. Competences you can train, attitude you cannot change. Let's be mindful of that. Again, having strategy is also key. As we move to our next panelist, which is Titi, I would like you to share with the audience today, Zimbabwe, as Kenya, has also made significant steps towards ensuring a proper framework for data protection. What were the challenges that most organizations faced in terms of aligning to data protection laws? And how did most of them overcome such challenges? Are there any best practices you would like to share with Malawi on how they can deal with some of these challenges?
Okay, thank you very much. I think when Dan and Tamanda came to Zimbabwe for a benchmarking tour, Zimbabwe is just a year and a few months old in data protection. But in that 1 year, we have actually managed to develop a training program for data protection officers. And we have done that in partnership with one of the universities in Zimbabwe, which is the Harare Institute of Technology. And we are proud that the head of data protection in Malawi went through that course, as well as the data compliance officer in Malawi went through that course. And we commend Malawi for believing in us. These are the networks that we were really talking about. We say to ourselves and to even Malawi, it's important to start. Zig Ziglar always says, or once said, that you don't have to be great to start, but you have to start to be great. And we are glad that Malawi has started. They started. And I think one of the important things that we learned in terms of the organizations trying or struggling with compliance was that lack of understanding of the legal requirements was a major challenge. So they were always questioning, what does consent mean? What does data minimization mean? So we have to constantly build the capacity around the provisions of the law. And I also commend MACRA for organizing this workshop, because as well as the stakeholder engagements that have been taking place to unpack the Malawi Data Protection Act from provision number 1 to the last provision. So this was the major challenge. But with the data protection officer training, we now have close to 400 people trained in Zimbabwe, now appreciating and understanding the legal requirements of data protection. The second challenge, like Immaculate shared earlier on, was for the data protection officers that were now trained, going back to their boards, to tell the board that data protection is a strategic issue, which we have to incorporate in our strategy, was also a major challenge. And there was always the question that, okay, at what level should the data protection officer sit in the organization? And we have always said the penalty for non-compliance can be up to 20 years for the CEO, who is responsible for the data controlling activities. And in Zimbabwe, it's up to 7 years imprisonment. And we have always asked the CEOs, would you give the responsibility of data protection activities to the cleaner or the security guard? If your liberty is at stake, you may go to prison for 20 years. So there has been a mindset shift, which was not there earlier on, where everyone in the industry thought that data protection is a small issue. We can get away with non-compliance. But then also we can get away with putting the data protection officer at a lower level. But institutions are now appreciating that their liberty is at stake, the organization's reputation is at stake, but also non-compliance penalties can actually be something that they wouldn't want to go through. So we have seen DPOs being at the level where they report directly to the chief executive officer, because you always want to make sure that person has your back as the CEO, considering the penalties involved. The other issue we also experienced, or that companies in Zimbabwe experienced, was the issue of then practical implementation when it comes to the realization of the rights of the data subject. So we're talking about data subject access requests. This is a new phenomenon for some, except for maybe for the banking sector, where a data subject can just walk into an organization and request for information you hold about them. So organizations were struggling in terms of how to implement the data subjects access requests management system. Not only that, but the consent management system, because what we then did before we started rolling out the Act, we did a baseline survey to try and understand the data protection ecosystem. What were the challenges? And then we had to employ appropriate regulatory interventions to address those challenges. And one of the issues we picked from the baseline survey really was that a lot of organizations, in terms of project rollout or service rollout, they were not implementing or doing data protection impact assessments. They were not putting privacy at the onset. Privacy was always an afterthought. So this is something that organizations now have to go back, review their strategies, review their policies, but also review their consent management systems so that they align with the data protection laws. The issue of breach management, I think Dan and Tamanda made reference to the fact that organizations must report data breaches within 72 hours. Organizations didn't know how to do that. Do we write a letter? Do we make a phone call? So these were basically practical implementation issues, and how we have dealt with that as Zimbabwe is that we have issued a guideline to guide stakeholders in the data protection ecosystem on breach management. We have also issued a guideline on consent management to assist stakeholders. We have also issued another guideline on how to appoint a data protection officer, what you need to look out for as an organization before you appoint a data protection officer, the qualifications of that data protection officer. We are free to share these guidelines with Malawi so that you can also see how we have done it in Zimbabwe. Over and above that, Organizations now are required to get the consent of parents. For example, I think Zimbabwe and Malawi have a similar setup. Anyone who is below the age of 18 is a child. So meaning organizations where you were used to collecting data from someone below the 18 directly from them, you now need to comply with the Data Protection Act, get the consent of their guardian and verify that consent as well as age verification. So what we have picked is that companies don't want to go through that hassle. They just still want to collect data from children. So we have also helped them by issuing a guideline on how to collect personally identifiable information from children. So these guidelines will go a long way in terms of assisting them to comply with the law. Over and above that, organizations that have got offices in Malawi, offices in Zimbabwe, offices in Kenya, we're also raising issue about how to manage multi-jurisdictional requirements. How then do we comply with the Kenyan law? We are in Malawi, we have to comply with the Zimbabwean law, the Botswana law. So we have also issued a guideline on cross-border transfer of information, what organizations need to look out for, what they need to put in place to make sure that the adequacy principle that Dan spoke about in the morning is actually realized and respected. The other issue, of course, I think Immaculate has spoken about that, the issue of budget. Companies are always talking about being constrained resource-wise, but what we have picked also is that there has been a lot of advocating for outsourcing the responsibility of the data controller if your organization is not ready to train internal staff. And the other challenge that organizations in Zimbabwe were raising or are still raising is how to manage third parties when it comes to data sharing agreements. Because organizations in Malawi will certainly be having agreements or will be having data collection arrangements with other countries or with other stakeholders in other countries. So how do we manage those vendor and third party arrangements? So these are also some of the issues, and we have also issued a guideline on data sharing arrangements that can be done. I think I'll stop here so that we can continue with the conversation, but those are some of the issues we have been picking from Zimbabwe. Thank you.
Thank you so much, Titi. I think we have actually heard it from ourselves. This is about lessons learned from our counterparts and getting the best practices. I think there were quite a number. I was just trying to jot everything down. There are over 8 practical guides and solutions, possible solutions that she has actually given to us. The first one, challenge, was highlighted as lack of understanding of the legal framework, and for that, they had to go into partnerships in terms of building capacity around the issues to unpack the legal framework. We've also heard that one other thing that was critical for them was the practical implementation of data subject rights, how to assess requests and consent management systems. And again, they had to do a baseline survey to understand the challenges and to actually identify possible regulatory interventions. And in that one, she also highlighted on the importance of doing a data protection impact assessment and not treating data protection as an afterthought. Let us have data protection by design, not as something that is an afterthought. We've also heard about positioning the position of the DPA, the DPO. We've heard from her that it's about the liberty of the CEO, and try to always ensure that the DPO reports directly to the CEO. At least elevate, don't really put it at the lowest level as one of the practical guides. We've also heard about the importance of having, I think that one goes to Dan and group, having guidelines on things like getting consent from parents for those kids that are below 18, about managing multiple jurisdictional issues, requirements, about, I think that one was on cross-border transfers. I think even on age verification as some of the things that we need to do. And again, she's also saying that for them, having guidelines on management of third-party arrangements was also key. And she has also been very upcoming to say that we don't have to reinvent the wheel. We can take lessons learned and adapt what they have for Malawi. So I think this is also something that will be key for the DPA going forward. That takes me to the question that I would like to pose to Dan. It has been highlighted, I think, by both from the two presenters, Titi and Immaculata, that the data protection officer is pivotal in terms of data protection compliance. And how do you view the role of the data protection officer in driving compliance within organizations, as organizations try to align themselves to the Data Protection Authority? Over to you, Dan.
Thank you, Togo. And let me also thank Immaculata and Sitsi, I think, for the good work I think that you're doing. And I think we are all learning a lot from your experiences. And I think we'll continue to draw from the experience as we grow as a Data Protection Authority. And coming to the issue of data protection officers, they are very key. And in terms of the framework or the scheme of arrangement under our Data Protection Act, I would call them the compliance champions because of the functions that have been given as the data protection officers. And again, just to emphasize, I think the crucial role that we are emphasizing on data protection officers. Tomorrow, we are having a special session just for the DPOs so that they are ingrained and they are familiar with their obligations and how they assist obligations in terms of compliance with the Data Protection Act. So it's very key. They will make or break you in terms of compliance with the data protection law. Perhaps maybe I can just highlight some of the obligations which have been put on the data protection officers under the Act. First of all, they will be required to advise data controllers and data processors on their obligations under the Act. And what does that entail? They entail that, first of all, they must be familiar with those obligations. If they are not familiar with those obligations, they will fail in their job. There are so many compliance requirements under the Act. City has highlighted a few. The issue of access management system, the issue of consent management system, the issue of record of processing activities, data protection impact assessments. All these issues, the data protection officer should be able to advise the data controller that these are obligations under the Act and how do we discharge or implement these particular obligations. Secondly, there will be an auditor, a compliance auditor, because they will monitor compliance of the data controller and data processor with the Act. So as an auditor, again, they will make or break your institution. We cannot overemphasize that. And thirdly, there will be our interface point between the Data Protection Authority and you as data controllers and data processors. So their role, indeed, we cannot downplay it. They are very, very, very important. And perhaps I should call and echo my colleagues here the issue of allocation of resources. It's imperative that we support these data protection officers, provide them with training, upskilling them all the time. And again, very important to get the right people to be data protection officers. Immaculata talked about Gen Z, and it reminded me of what Elon Musk is doing with the Department of Government Efficiency in the US. He is using Gen Z to surgically review the budget of the US government. So if you manage them, they will be able to help you a lot. So it's very key that we get the right people to be data protection officers in this. And again, I think as a data protection authority, that is just starting. That is just starting, and we are new kids on the block. We are forward-looking, and we looking at developing a framework for the DPOs. Sister Immaculata has talked about the partnerships that they have. In Kenya, I think with the School of Government. In Zimbabwe, there is Higher Institute of Technology to provide training for the data protection officers. We are also looking to do the same. And also maybe having a framework or guidelines in terms of what qualifications are we looking at for the data protection officers? What experiences are they going to, do we need for them to be effective in their job? Thank you so much.
Thank you so much. Before I take questions from the floor, I would like to ask my panelists, would you like to input on any of the questions that I asked the other panelists, something that you think is so burning that you think you should input in as some of the best practice in trying to ensure compliance on the questions that I asked the other panelists? I would start with Titi. Anything you would like to add on Dan's, the role of the DPO, and Immaculata's practical guides?
Thank you. It's just that we don't have a lot of time, but we will keep sharing and conversing during lunch in the next 3 days. I think for organizations that are represented here, the key message that I would want to send out there is that if you think compliance is expensive, try non-compliance. You have already seen in the Act that the penalties are very high, as well as the level of imprisonment is also very high. So I would urge stakeholders in the room to work with Dan and team, the Data Protection Authority, to make sure that they comply with the requirements in terms of the law. But also just to say that data protection officers are actually the cornerstone of the whole data protection ecosystem. So as organizations, we need to constantly or continuously build their capacity so that they know how to implement this piece of legislation. In Zimbabwe, we are already planning what we call winter schools and summer schools for data protection officers, so that we delve deeper into the different issues that they deal with on a day-to-day basis. Because compliance is a journey, it's just not a one-day event. And I think I applaud MACRA for the approach that they are taking in terms of ensuring voluntary compliance and encouraging compliance. And with that approach, we have seen that in Zimbabwe, you take along a lot more people than when you are trying to be punitive, rather be correctional in the approach. So I would say this is one of the issues we have also learned in Zimbabwe. And coming on to the issue that Immaculate actually spoke about with regards to the issue that networks are critical. You cannot go it alone in the data protection journey. Even amongst yourselves as stakeholders, in Zimbabwe they have already created a data protection association, Data Protection Officer Association, and this association, they have created their own network for discussing issues that affect data protection locally. So it's also a takeaway that you can think about as data protection officers in Malawi or the budding data protection officers in Malawi. So the network is critical, not just from a stakeholder perspective, but even from a regulatory perspective. And as Zimbabwe, I want to say we are a phone call away if you need support from a regulatory perspective, even from sharing best practices from industry. I think a lot of the organizations in the financial sector in Zimbabwe are compliant with the data protection law. Yes, we are having our deadline for licensing, which is 12 March this year, but we have seen a lot of the financial institutions actually complying with the regulations. This would be really my comments to some of the issues. Thank you.
Immaculata, 1 minute.
Just two issues which I didn't speak to. Our framework allows for alternative dispute resolution. It's a great way of addressing, preempting in case you get into a breach. The second thing I would like to speak to, that partnership with other organizations. In the case of Kenya, we've benefited tremendously from our relationship with not only the British High Commission, which helped us come up with our first strategy, but mostly GIZ. What that partnership has done is to even train our staff on data protection with the University of Maastricht. They've also helped us get experts who, of course, because the European Commission has had longer duration, we've had experts coming to train and also help us in some of the complex investigation. Three, if you want to go into enforcement immediately, it's important to train your staff on investigation so that they understand what is expected, how to secure evidence, and how to write a determination. Those are important skills as you embark on that journey.
Dan, over to you, 1 minute.
Yes, thank you. A quick one and a short one. I think just drawing from the experiences from Zimbabwe and Kenya on the importance of partnerships and networking and putting privacy at the core of our discussions. As we are breaking new ground, I think there will be some resistance, but I think with engagement, continuous engagement, discussions, I think we should be able to overcome any resistance. Thank you so much.
Thank you so much. Do we have time for questions? 5 minutes. I'm being told that we only have 5 minutes for questions. If you have any burning questions from our panelists, can we at least take a few questions? They are here, they will be around for the whole duration. We can take some of the questions outside, but let's hear a question each from anyone. Don't have more than 2 questions so that we can also have others asking the same questions. Yes.
Thank you so much, our panelists, and Togo as well. I just wanted to learn from Kenya as well as Zimbabwe in terms of how you have dealt with issues of electronic medical records. We are aware that in Malawi, we are now getting more and more into electronic medical records, and we have a lot of systems that are actually storing electronic data for clients that visit the facilities. So how have you dealt with that? And as well, maybe to Danny, in terms of what is the plan for Malawi, knowing that we need to deal with other ministries as well. Thank you.
Thank you, panelists. I want to ask in a similar vein, what is the effect of cancellation of registration as a data controller or processor of significant importance? I'm asking under the guise of those that are regulated, say by the central bank, we apply for a license and then you revoke us with our registration under DPA. What is the practice in Kenya and Zimbabwe, and what is the plan for Malawi? Thank you.
I think we can take those ones.
I can go first. On the questions about, unfortunately I didn't hear their names, so I will go ahead and address the question. On the issue about data protection, health records, I totally agree with you. Health records are what we call sensitive data in the definition of the Data Protection Act in Kenya. Given that's significant, in Kenya, irrespective of whether you have more than 10,000 data subjects, when you fall within that category, it's mandatory for you to register. Why is it important? Because it's not just Malawi that is automating, we're also automating as a country a lot. what is important is when you start the registration process, you then start to understand basic things where you are able to just there map out and also understand what data protection principles are, where you're storing information, how you're processing it, and so on and so forth. From a regulator's perspective, point of intervention, please do not wait until it is too late. I know the PS said we have a tendency, which is not unique to Malawi, of having new institution and then we wait and see. When you are a regulator in data protection, you can't adopt a wait and see. Because the wait and see might be so sequential, it might be a breach of personal information out there. My suggestion from a regulator's perspective, map out the most critical institution, and one of them is health, Ministry of Health. Audit, undertake an audit, because under the Act, you have the powers to undertake an audit. Once you audit, it helps you have a feel what the gaps are. And once you audit, you're able to advise them to undertake a data protection impact assessment and also understand where their data is stored and then so build their capacity. Be proactive. Otherwise, if you wait and see, you could be compromising data that you could have otherwise saved in case of a breach. It's not to say breaches will not happen, but the beauty of understanding where your data is, you're better prepared in terms of mitigation. You have you have mechanism of making sure that data, if at all there's a breach, it is safeguarded. So for me, when it comes to medical records, it's important to be proactive. It is not enough to say we are automating, let's make sure it's safe. The second question is, I want to suspect this is a digital lender, but let's assume it's not. From a Kenyan experience, the biggest challenge we've had with that sector of being regulated by central bank and them not, and then you come to us, it's lack of compliance. Digital lenders have this habit of accessing personal information from third parties who are not part of the contract. Please remember, earlier presented is lawful basis. It's important as digital lenders to do the following: register, adhere to the Data Protection Act, and please do not access people's call or contact list and use to harass, because that is the issue. When that happens, then don't complain when your license is revoked, because then you're being non-compliant. I don't think any data protection authority wants to revoke any license unless they have established there's a need to do so. Just comply. Data protection authorities are here to help you walk the journey, seek an advisory, seek a training, seek an audit. They are here and paid with taxpayers' money. They should be able to help you in any of this or refer you to the necessary people. Thank you.
Thank you. I think just taking from where Immaculata actually left is that in Zimbabwe we have adopted a sectoral approach. So what we have done is we have mapped the key sectors where we think there is massive collection of personally identifiable information as well as sensitive information, and that includes the health sector. So we have mapped the education sector because we are thinking of our children, and 67% of the population, for example, in Zimbabwe are the youths. So we have also mapped the education sector, we have mapped the health sector, we have mapped also the tourism sector as a sensitive sector which we need to keep an eye on and constantly do assessments in terms of whether their data collection practices are aligned with the provisions of the law. So with the health sector, we were fortunate enough that when the Act was promulgated in 2021, in 2022, the Ministry of Health was digitizing the health record system. So we've got what we call the Impilo Health, which is the digital system containing the health records of Zimbabweans. So when that started in 2022, 2023, already the Ministry of Health invited POTRAS as the designated data protection authority, that before we even start coming up with the application itself, we need you to be on board so that you guide in terms of how we are going to be doing the data mapping, even in terms of access controls. Should it be every nurse who will be able to access the data? What physical or online controls do we need to put in place to make sure that we don't have everybody else accessing this health data? So the sectoral mapping has really helped us to look at the sensitive sectors, and that includes health, the health sector. And also the fact that collaborative regulation is very key, in the sense that Ministry of Health and Ministry of ICT are actually working hand in hand, particularly when you look at the telemedicine project, which also includes the digitization of health records. So that collaboration has actually helped us to come up with tools, to come up with mechanisms to assist in the development of this application that is going to be applied in all hospitals in Zimbabwe. And I also wanted to say on the issue of the regulator in the banking sector, you having a license from the Reserve Bank, and then the Data Protection Authority are withdrawing your license on the basis that you don't protect personally identifiable information. I just wanted to say, in Zimbabwe, we actually have a memorandum of understanding with the Reserve Bank of Zimbabwe, where we have agreed that when it comes to digital financial services, that is where we assess the level of cyber security that is on our mobile money platforms, whether it's online, whether it's on your phone, we will collaborate and make sure that we share the results of our assessments. Number two, we have also agreed with the Reserve Bank that whoever is registered with you as the Reserve Bank also needs to make sure they have a data controller license. So we check up on that requirement. So that memorandum of understanding is actually assisting us to meet our two mandates, their mandate as well as our mandate. Then the third issue really is that we have agreed that we will conduct joint awareness programs, not just on the aspects of data protection in all other sectors, but specifically in the banking sector, so that the banking sector complies with those requirements. So that has been the approach in Zimbabwe. Thank you.
Yes, thank you. I think let me start with the question on the effect of cancellation of a registration as a data controller of significant importance, where you are also regulated by other entities like the Financial Services Regulator. So the effect of a cancellation, I think I will have to be blunt, are quite dire. This is regardless of whether you are also regulated by maybe it's a bank or other regulators. The Act has specifically stated that if you are a data controller of significant importance, you cannot process personal data without being registered with the authority. Meaning that if your registration is cancelled, you cannot process. And if you continue to process, then you are in violation of the Act, and the penalties there are quite stiff. So I think the solution is we just have to make sure that our registration is never cancelled. That's the easiest answer there. Coming to the issue of digitization of the medical records, we'll follow the approach of Zimbabwe. That is a sectoral approach, because we recognize that the requirements may be different amongst the sectors. Some sectors are processing sensitive personal information, which requires additional activities to be undertaken in respect to that information. So it will be a sectoral approach, and we'll be engaging each individual sector, helping them in terms of compliance, because we recognize that we are just starting and they cannot do it on their own. We may have to put in place some guidelines in terms of the standards that we are expecting for each particular sector. And maybe also for them as well to do what is called a gap analysis. Check what are the standards that have been prescribed in the Act. As the current status, where are we in terms of compliance? Identify those gaps and put in place policies, procedures that can help you to be up to the standard that has been set by the Act. Thank you.
Thank you so much. I would have loved to take it further, but our time is up. And I would like to thank, as we are coming to the end of the session, I would like to thank our panelists. Can we please give them a big hand of applause? I would also like to thank the audience for being so active and for the questions and the interaction. Thank you so much.
Thank you so much, Thokozani Chimbe and your panelists. You may take your seats. This marks the end of our morning sessions. We'll break for lunch. Lunch is an hour. We'll be back here at 10 minutes to 2. Lunch is being served at the main foyer where FDH Bank is. Let me also take this opportunity to invite you for a cocktail tonight after our afternoon session. This cocktail will take place here at BICC in the VIP room. This is where the auditorium is. So when we go up the steps, we'll find space there where we shall have our cocktail. Our cocktail is starting at 7 p.m. Please let us attend and network. Mr. Chione did say that networking is important, so this function will give us an opportunity to network. Now we can break for lunch. Thank you. May we take coupons as we are exiting the room? There will be people by the door that will give us these coupons.
There's such a rush, my baby, slow down, come find your love. I'm hoping you see me, come serve it up. Loving when you stir it up, that body belong on TV. Oh, this feeling I can't hide. You're feeling up my mind, and I just don't know why. I just don't know why. Five lives, five lives, five lives.